is holy. You are so holy to me. And I call you holy. And your name is holy. And holy you are. And holy you'll be. Yeah. Oh. Can y'all help me sing it? Come on, say, I call you holy. I call you holy. Your name is holy. You are so holy. You are so holy to me. Oh, I call you holy. I call you holy. Yeah. Your name is and holy you are. Holy you and holy you'll be. Come on, say this. Yeah. Say, I call you righteous. Say, I call you righteous. Your name is righteous. Your name is righteous. You are so righteous. You are so righteous to me. Oh, I call you righteous. I call you righteous. Your name is righteous. You are righteous. You and righteous you'll be. Say, I call you faithful. I call you faithful. Your name is faithful. Your name is faithful. You have been faithful. You have been faithful to me. Oh, I call you faithful. I call you faithful. Your name and faithful you are. Faithful you and faithful you'll be.
Well, good afternoon. It is so good to see you here, and to all of you who are joining us online, we're so grateful to see you virtually. Welcome to Second Baptist Church, a house of hope, and our special Black History program. I call it a part of our empowerment series. Every year at Second Baptist, we do sessions to educate, empower, and inform our community in honor of Black History Month. I am Pastor Todd Johnson, and I serve here as the pastor of Second Baptist Church, and I'm so grateful that you are all here with us in the house and that we are watching online. We are live right now on Facebook and YouTube, so if you're watching, if you're tuning in, be sure to like and share and tag somebody who desperately needs this information. This is going to be an informative and engaging time with not only some public servants of our county, but also some local life insurance agents who will give us some very important information about what we call securing the future. As a pastor now for 10 years, and I'm sure other ministers have been in the same spot as me, we have seen so many families go through the tragedy of death and then the dual tragedy of not being prepared financially for death. We preach it all the time. Death is a reality of life. Until the Lord returns, people are going to pass away. And even if they don't pass away, they may become incapacitated or not able to do or take care of their own functions, or have to be put into a nursing home or some sort of facility, and they need to be prepared. We need to be prepared as families and as a community to properly secure our assets, our property, our bank accounts, our finances, and beyond that, leave a legacy to generations in the future. And I just want to throw a plug in for this, because I'm part of that generation that's talking a lot about financial matters and generational wealth, and we like to say get in the bag, secure in the bag. That means making money and making a lot of money. But really, if we don't do the basic things that will secure our assets, our families, then we're really not serious about it. And so I want our community to be serious about this. I have to be blunt. I hate to see families have to fundraise when a loved one passes away. I know it's necessary sometimes. Sometimes there are just things you do not foresee, but that's what insurance is for. That's what estate planning is for. It's for those things you do not foresee coming around the corner, but we need to be prepared for. In the African American community, we often say that it seems like every generation has to start over from scratch, and it shouldn't be that way. We should be able to leave a legacy, a leg up to generations to come, and make sure that we prepare our children for a vibrant future. And when we talk about other cultures and how well they may do financially and cooperative and work together, I say don't just talk about it, learn from it. and do what you can do to build up your own community. And so that's why we're here today. So as I said earlier, before we went live, if you have your phone on you, if you would do me a favor and silence that phone, if possible, check and double check. Sometimes you thought you hit the button and you didn't. So we want to make sure that your phone is on silent or vibrate. If you're a Facebooker or a YouTuber, you're more than welcome to go on to Facebook or YouTube and share this video. And I'm sure that the people who follow your timeline or your family and your friends would appreciate that you made them aware that this information is available. Secondly, I want to say that this is a part of what Second Baptist does. We believe that ministry extends beyond the church and beyond church services. And that's why we help to sponsor our Martin Luther King Day Youth Workshop. And we're doing this today. And we're actually taking a group of youth, about 40 kids, to the Oh Wow Science Center tomorrow after church. Because this is what we do. We try to find ways to extend the love and grace of God beyond just worship services. And I want you in the future to be sure to follow along with what we're doing here. Even if you're not a member of our church, you don't have to be a member of our church to participate and be blessed by what we have available. I do make sure that I reach out to all of our fellow pastors and community leaders and all of the newspapers to make sure that they know what is happening and what they can benefit from. But I also know that there's nothing like a personal touch. And we want as many of our community members to be informed about the positive things that are happening right here in our community. Amen? Amen. Well, we're in church, so I'm going to open with prayer and then introduce our guests. So let's pray together. Father, we thank you and we bless you for the opportunity to be informed and educated about very important matters that concern our families, our finances, and our future. We thank you for the expertise and the knowledge of those individuals who will be sharing with us today, answering our questions and providing this vital information for our benefit and our good. Lord, I pray that this messaging goes out far and beyond this session today, that even on the virtual stage, even on Facebook and YouTube, individuals will come across this information and be inspired and motivated to take the next steps in securing those important matters that concern their families and the generations to come. We thank you, oh God, for your blessing of a beautiful day and pray your blessing over these affairs today. In Jesus' name we pray, amen. Amen. We have three presenters today that are going to speak to us and answer our questions, provide some information. They've already been passing out pamphlets. If you are watching virtually and you can't get a physical pamphlet in your hand, we will have some extras here at the church. I'll leave them out in the foyer and have them here in the church if you come to service, if you so happen to visit, so that you can get a hold of this. And I'm sure you can pick them up at the judge's office downtown at the Trumbull County Court. Our guests today are my good friend, Judge James Frederica, who I have served with on the Warren Civil Service Commission, and now he is the Trumbull County Probate Judge. Let's give him a hand for being with us, Judge James Frederica. Following him will be Chief Magistrate Chris Chavone, who is also working with the Trumbull County Probate Court, and he'll be providing information about estate planning and things of that nature. And then our own, Mr. Herb Caldwell, the one and only, who works in life insurance and real estate and products and with BSH Incorporated, and they're going to be our presenters for this morning, this session. So, Judge Frederica will be doing our first session. He will provide information and then open up for Q&A, all right? And let's receive him and give him a great big hand praise as he comes.
A little shorter. First of all, I want to thank Reverend Johnson for inviting us here to speak with you this morning. I want to thank Herb Caldwell, who also extended the invitation and works with me at the probate court in the veterans program that we have. And I want to thank you for coming. I can't tell you how much I love getting out and talking about the probate court. That's why almost every time I receive an invitation, I make my best effort to get out so that I can speak to people about the probate court, because for whatever reason, and I don't know what that reason is, people fear the probate court. I can't tell you how often I hear people tell me, oh, you're that judge who's going to take away my freedom, or you're that judge who's going to take a third of my estate. And nothing can be further from the truth. And that's why I'd like to get out and talk about the probate court and meet with people and try to explain to them that we provide a tremendous amount of service to folks. We make sure that your assets go to where you want them to go. And we make sure that people do not take advantage of our elderly, do not take away their assets during their lifetime, and that their assets are preserved for their benefit during their lifetime. So, Todd?
Yes.
Will help with the zapper. The probate court is important to every person in this room and to all those watching online. And this is the reason why it's important to you, okay? We do so many different aspects that touches the lives of every person in Trumbull County. We handle wills and estate administration. Someone dies, we make sure that their assets go to those people that the deceased wants their assets to go to. We handle all disputes or matters relating to trusts that are created in wills. We do adoptions. We do marriage licenses. You cannot get married without a license, and we handle the licenses in the probate court. We handle change of names. We also do mental health commitments, which is that is one of the more difficult aspects of the probate judge's life, because we have to make sure that those people who are either a danger to themselves or a danger to others, that they are appropriately treated and committed to some health resources, so mental health resources, so that they don't harm themselves or harm others. We do issues relating to wrongful death, and we also do guardianships. And then we have, in addition to those statutory responsibilities, we go outside and touch the community in 3 particular areas. We have a senior court where people over 60 years of age, when they get in trouble with the law and it's related to their age, we assist them in their legal matters. We have established a veterans court over the last several years where we help veterans who have issues with the law. We are there to try to find solutions for them as opposed to punishment for them. So we have Veterans Court, and we also have one of my favorite activities, which is the Guardian Angels. And in the Guardian Angels, we go to nursing homes, we visit with people who have no relatives, who have no friends. We act as friends to them, and we also keep track of making sure that the nursing homes are providing appropriate care for those people who have no one else, who don't have anybody to act as an advocate on their behalf. So these are the programs that we have in the probate court outside of our statutory responsibilities. But what I want to talk to you about today are some of the things that you may do that will help you in the management of your assets in your estate. Just to give you a little bit of an idea of how much community involvement we have, I did provide a few photographs of our adoption day, and you can see the joy of the kids and how much fun it can be when we are bringing families together rather than tearing families apart. Now, getting to the primary basis of this talk today, I want to talk to you about 3 things, okay? I want to talk to you about the 4 documents that everyone in this room should have to manage their estate. And I also want to talk to you about some of the things you can do to avoid expenses later on through, a lot of talk about in the probate court is so expensive, et cetera. We're going to talk about some of the things that you can do, some simple things that you can do that won't cost you very much money at all, which will save you a tremendous amount of money. And we're going to talk to you, Chris is going to talk to you more about the specifics of how you implement those things that I'm going to speak to you about. Primarily, I'm going to talk to you about wills. Let's start with the basics, okay? What is a will? A will is a document that sets forth how a person would like to have his or her probate property distributed upon death, okay? Now, there's a difference between probate property that passes through the probate court and property that passes outside the probate court. And we're going to talk about the difference, and in this difference is how you're going to be able to save expenses during your lifetime and also upon your death for your family. Who may make a will? Anyone who's 18 years of age or older and who is of sound mind and who is not under undue influence. Those are the people who can make wills. How is a will made? A will must be written and it must be witnessed in a special way. We're going to talk about that a little bit, but it has to be witnessed by at least 2 disinterested persons. If you make a will and you have the will witnessed by a person who's a beneficiary of that will, that person cannot inherit. So it has to be done in a special way. And the best way to ensure that the will is done properly is to have that will prepared by an attorney. Now, there are wills that go through my court that are not prepared by there are no problems with. What I can tell you as I stand before you today, that within the last month and a half, I've had 3 or 4 wills that were not prepared by attorneys, that were not done in the appropriate fashion, and were not admitted to probate, and that the assets are not going to pass by the way of the intention of the person who made the will because they didn't execute or prepare the will in a proper fashion. So now you know what a will is, you know how the will has to be made. Can you change it once it's made? And the answer to that is yes. You can change your will at any time once it is made before you die. And you don't have to remake the entire will. You can do it by way of what we call a codicil, making minor changes to the will through a shorter document, which is also less expensive to prepare. How long does your will last? It lasts until you revoke it. A will has no force or effect until you die, and you can revoke it before you die at any time. How is it revoked? You could tear it up. You could create a new will. That's how a will can be revoked, and then you can make another will if you wish. Does a will increase your expenses in probate? The answer to that is absolutely not. A will does not increase your expenses in probate, and in fact can decrease the expense of probate. So if you make a will and you appoint an executor in the will, you can have that executor serve without bond. If you don't make a will, then I get to pick who's going to handle your estate, and you don't want that. You want to pick who you trust, because I don't know you personally. I don't know your specific intentions, your specific desires. So if you make a will and you appoint an executor in that will, or an executrix in the case of a woman, then you decide who's going to handle your estate. And you can say in the will that you're waiving bond. If you don't appoint an executor, you don't have a will, and I have to handle your estate, that your estate is what we call passing by intestate, then I have to appoint somebody and I have to fix a bond, which costs money, which you don't want to have happen. And it could also reduce expenses, because in the will you could give your executor or executrix the power to sell property, to give them certain powers, et cetera, so that they don't have to come to court every time they make a move to file a motion or something like that, which costs extra money in terms of attorney fees, costs extra probate expenses. So not only do you want to have the will, you want to appoint somebody who you trust to handle your estate, and all of that will save you expense in the probate process. How large of an estate do you have to make a will? If you own any personalty or you own any real estate, you should have a will. You don't have to have any specific amount of money, and over time, you'd be surprised how your estate can grow. Automobiles, you're paying off mortgages, the possibility of inheriting money, etc. All of those things can increase the value of your estate. You may say to yourself, well, I don't have much now, etc. You can't rely on that. Circumstances in life change. And anybody who has real estate or anybody who has personal property need to have a will. Can you dispose of your property in any way you want? The answer is generally to that is yes. However, a surviving spouse and minor children have certain rights which you cannot defeat with a will, but primarily you can leave your property to anybody that you desire. A question that often comes up is, what happens to property held in the names of more than one person? And this is where we get to the idea of formulating or putting together your estate plan. If you own property with somebody else, if you have a joint bank account that is not a survivorship account, then a portion of that property will go into your estate, and the other portion of that property will not go into your estate, remains in the hands of the person that you own joint property with. What you want to do is you want to set up your accounts, your real estate, your automobiles, your personality, when you can, in the names of whoever you want, surviving a spouse, a child, etc. And you want to have it in survivorship property. For example, you go to the bank, you have a bank account, and on that bank account, you want to put, let's say, your only son, and you say to the bank, I want this property to be held in survivorship. When you die, that property does not pass through the probate court. That property passes directly to your son or your daughter, okay? That property goes directly to them. Two things happen. Number one, it doesn't have to go through probate. There's not an expense involved in handling the property through probate. Number two, the property passes directly to the person you wanted that property to go to. You can do that with real estate. You could have it a transfer on death with respect to your real estate, and that real estate will not pass through the probate court. It will go outside of the probate court. We have nothing to do with it. It's done by way of affidavit, and the property passes away from the probate court directly to the person who survives. You can do that with automobiles. Some of you have IRAs. You may have a retirement account someplace. You can always put in the beneficiary of that retirement plan or that IRA. That property will pass outside of the probate court. So you can set up your estate such that the property that passes through the probate court is minimal. But you should still have a will, because there are things that you may have overlooked, you may get later on, et cetera, that are not in survivorship. But if they are in survivorship, it passes outside of the probate court, and therefore saves you money, saves you time, saves you an opportunity of having the lawyer do all these things for you. And what does it cost you? Very little. It costs you nothing at the bank to put an account in a survivorship. Easy to do. All you have to do is talk to your banker, and they will do that for you. It costs nothing to put a title of a car, transfer on death. All you have to do is set that up with the automobile dealer. I just bought a car here recently for my wife, and put it in her name, transfer on death to me. Okay, so you can do that. That car does not pass through probate at all. Now, what is the significance of that? The significance of that is that there's what we call full administration, which Chris is going to talk to you about briefly, and there's called a release from administration. If not all of your assets are in survivorship mode, okay, if they're set up that way, none of it passes through probate, and you can do what we call a release from administration, which is a short, easy, simple process which usually costs less than $500 in attorney fees and less than $100 in costs, and your estate can be handled if most of your property is being set up in either transfer on death or survivorship, etc. So those are the things that can save you money, save you time, and save you a great deal of expense. What happens if you die without a will? Okay? If you die without a will, then it's up to me to appoint someone to handle your affairs, to handle your estate, rather. It's up to me to make sure that the property goes by way of the law, not by way of what you would have wanted, but by the way of the law, okay? Whatever the statute says. So for example, if you are a man with 2 minor children and you die without a will, and if you have a surviving wife who is not the natural or adoptive parent of your children, the law says that she gets the first $20,000 of your estate, and then she'll get a third, and each of the minor children will get a third. Who thinks of that? Okay, who says to themselves, boy, if I die, I want to leave $20,000 here, and then I want my estate divided up 3 ways with my wife? Well, the state of Ohio thinks that way. That's the way they set it up. So if you die without a will, I have to follow the law. I have to divide up your estate, not the way you would have wanted it, because I don't know what you want because you didn't put it in the will. I have to do it according to what the law says. And that example that I gave you is pretty much what the law says you have to do. So I have to follow a cookie cutter way of dividing up your estate that the state sets forth if you don't have a will. One of the big items that we're going to talk about later is life insurance. So if you have a $10,000 life insurance policy that you purchase, and they're going to ask you, who do you want that policy to go to, okay? Or you want it to go to your estate, you want it to go to your spouse, you want it to go to your children, whatever. If you say you want that policy to go to the estate, then we have to handle it internally at the probate court. You do not want that. You want to set it up with a beneficiary. That policy will pass outside of the probate court. It will pass directly to whoever the beneficiary that you name. And again, that's less assets that have to be dealt with at the probate court. Okay, who should draft the will? As I mentioned to you earlier, you can do these wills they have online. It's dangerous. My thought is you can have the best route that I've seen over the 8 years that I've been the probate judge is to have a lawyer draft your will for you. It is not that expensive. I searched around because I knew I was coming here today. I talked to a couple law firms about what they charge for these important documents that you need to have, and we're going to talk about the other 3 here very quickly. And for around $300, you can have all of these documents prepared by a lawyer and be relatively certain that they will be prepared in a proper manner and not have to worry about, did I dot all the I's and cross all the T's? Okay, that's the discussion on wills, and I'll take questions on that in a minute. Let's see. Healthcare power of attorney. I'm going to go quickly through these. Everyone in this room should have a healthcare power of attorney. It's a legal document that authorizes another person to obtain your health information and make health care decisions for you. I'm always told, I don't want somebody else making decisions for me. I want to make my own decisions. It doesn't work that way. Healthcare decisions can only be made by the person you appoint when you can't make the decision for yourself. If you're comatose, you're in a serious accident, you can't make that decision. You need the healthcare power of attorney so someone can make that decision for you. And it's often drafted what we call a living will. Living will is a document setting forth your directions regarding the administration of life-sustaining support or resuscitation. Only applies if you are unable to communicate or are permanently unconscious or terminally ill. I'll give you a personal story about this. My dad, he has a doctor for a son and a lawyer for a son. He's preparing a living will, and during the preparation of the living will, he appoints the lawyer as the person to make the decisions regarding the life-sustaining support. And I said, Dad, you got to name Dave as the person. He said, no, I want you to do it. And I'm going to tell you right now, I do not want any tubes in me. When it's time for me to go, you let me go. I want to make sure that you understand that. And he made me repeat it back to him, that I understood that he did not want tubes in him. He did not want to be sustained. Now, other people have a different view. And believe me, over the practice of law for 35 years, people have expressed the views to me. But that was what he wanted. And that's what he conveyed to me. He prepared the living will. He made me the person to make that decision. And I clearly understood what he wanted. And the time came, unfortunately, where I had to make that decision. And finally, the power of attorney. A power of attorney is a document granting another the authority to make personal, financial, and business decisions for you. Your agent serves in a fiduciary capacity, has to make the decisions in your favor, and it's often drafted to take effect upon physical or mental incapacity. So they can't make those decisions unless you are physically unable to make the decision yourself, or you're not capable of making that decision because it's a mental problem or deficiency. So those are the 4 documents that you should have in your portfolio so that you can prepare as we go on in life. So that's pretty much what I wanted to say about those documents. Are there any questions about anything that I have? Yes, ma'am. Hi. Okay. The concern is, and Ms. Rucker and I have talked about it in the past, where an estate has not been set up. A parent may pass away. Their child, who may now be an adult, living in the house with the parent passes away, and there's no estate set up, and they need the property remains in the parent's name. And this can be handled, okay? You come to the probate court, we can resolve that issue. It will become a problem later on when the child, or the child who becomes an adult, wants to transfer the property. Won't be able to transfer the property until an estate is set up, the matter is handled in the probate court, and the property is appropriately transferred to the child. So, and it can be done. It is not an expensive process, but it has to be done. It's a legal proceeding that must be done through the probate court. Yes, ma'am.
A land trust, will that assure you that your property will go to your children instead of going into probate? How does that work?
Well, trust matters are another entire discussion, okay? And we didn't touch on it today. When you're dealing with your estate, there's lots of things you can do that I've talked to you about that you can do and then not have to form a trust. Most of us Our major assets are our home, our bank accounts, and our cars, okay? And those are easily handled by way of setting up survivorship accounts or transfer on death things. But there are some of us who have more than that. And when you have more than that, then you need to be thinking about, should I have a trust? And should all my property be in a trust? I had a friend who many of you know in this room. He was my first client, and I got very busy. I was trying cases and stuff, and he although I represented him all throughout his lifetime, he became worried about his estate, and he decided he was going to go to one of these presentations put on about estate planning. And he went to it, and he hired a lawyer to prepare his estate and stuff, and he went through that entire process. And so it depends on what you have. And I can't tell you, okay, because I don't know each and every individual's personal financial situation. But if you go to a lawyer, he can advise you as to whether or not you need a trust. And there are some of you in this room who probably do need a trust, okay? There are many of you who don't, but there are some of you who do. And the only way that you're going to be able to determine that, in my view, is if you go and talk to an attorney. Who do you call? You call a trusted, your family lawyer. He'll either refer you, you can call the bar association, you can ask your friends and neighbors who they went to, and then go to them, you explain your assets, go through that entire process, and they will advise you as to whether or not you need a trust or you don't need a trust. Many of us don't, some of us do. Yes, sir. Way in the back. Well, usually I have not done domestic work in many, many years, so I'm not going to speak but too precisely on that subject. But usually in the divorce decree and in the separation agreement, the spouses give up any rights that they might have with respect to the other person's estate. Okay, that usually is in the divorce decree. Okay, so that usually resolves most of the problems. But if you are divorced, you do not have a surviving spouse, and you can prepare your will and have your property distributed to your children in any way that you decide to have it distributed to them. Your ex really does not inherit from you if you are divorced, and your decree, as I said, usually contains language that they waive any right to your estate. So, right. If there are minor, that the money from or the assets that you leave to a minor, will go into a guardianship for that minor until they reach the age of 18. Okay. Yes, sir.
Adding a third name on all bank accounts and even on a house. If something happened to me, it goes to my wife. If something happened to both of us, will it go to that, the name will be on there?
My mother-in-law called me up on the phone one time and says to me, I was at the bank and I tried to put the account in the name of her 3 children, which one of them was my wife, okay? And they said they wouldn't do it, okay? I said, insist on it. They'll do it, okay? She insisted on it. They did it. And the money, the survivorship account would have gone equally to the 3 of them on her death. So you need to insist on that. I'm not sure about the real estate end on if you, Chris, can you get?
So with the real estate, you can do that, but you may want to be careful about that, because if you add a third person onto your real estate, then they have immediate ownership. And obviously, if it's your child, you trust your child, then great. But I have seen when I was in private practice a couple of times where somebody added a third person on the real estate, that person ran up a lot of debt and ended up having liens put on their parents' house. So, it's something that you can do, and it is a good estate plan for probably 98% of people, but you get that small 2% where there could be an issue. That's why they now have a transfer on death deed. So you would own the real estate jointly with survivorship with your spouse, and then you have the transfer on death language on that deed, where if something happened to both of you, then it would transfer on death to a child or to your children equally. And that might be something that setup might be a little bit better, depending on your situation. And again, everybody's situation. Yeah, if it's set up properly with either the survivorship language or the transfer on death language, then it would go to that person.
Right. For you, it sounds, with respect to your question, you put 3 names on it. It sounds to me like you and your spouse then transfer on death to your child. Then you don't have to worry about the situation where during your lifetime, your child would, if your child, and I'm not suggesting it would, but if he got in financial issues and they did put liens on, it wouldn't affect you because he has no interest or she has no interest until you and your spouse pass away. Okay. Any other questions? Yes, ma'am. Good afternoon. Yes, that lien was on the property when the person dies. The person who gets the property that's transferred on death, the lien is on the property. Yes, ma'am. There, we get that question a lot, okay? And everybody's situation is different, and that's why I suggest sit down with your trusted family lawyer, have a discussion with them, and they can give you estate planning advice. See, we can't give you advice from here, okay? We can give you suggestions on what documents you should have, but I can't say, this is my advice, okay? We're not allowed to do that anymore. Once, a lot of things happen to you when you become a judge. First of all, first thing that happens is you're no longer an attorney. You can't practice law anymore. And the second thing that happens to you, when you get to be my age, they tell you you're constitutionally impaired at age 70. You can't run again, okay? So this is my last term, and just this past week, I have only 4 more years left, and then I'm in retirement, so not allowed to run again. Okay. All right, Chris is going to give you a little bit of idea of the probate, and if you do the things that we suggested, not advised, but suggested, that you'll be able to avoid some of the expense of probate.
Thank you, Judge, and thank you, everyone, for having us to this beautiful. I want to thank everyone for having us here at this beautiful church. And it's great to get out again amongst the public and be able to give these informational talks. As the judge said, there's a lot of misconception about the probate court, and we just want to try to clear that up. I do want to say one thing. The gentleman in the back who talked about the situation where you have a divorce and minor children, and I know the judge was talking, there was a question about trusts, and everybody's situation's different. That might be in a situation where you may want to have a trust. So that way you can leave all of your assets in trust for the minor children until they become adults. That might be a situation. There's a couple different situations you may want to have a trust. That would be one that you may want to look at that. So what I'm going to talk about are some different types of estates that we have at the probate court. The judge had mentioned a release from administration versus a full administration, and I'm just going to go through those briefly because I know we are running a little late on time. So bear with me 1 second while I get to there we go. Okay, so you have a release from administration, and that's an alternative for smaller estates. It is a very streamlined process compared to a full administration. Usually a release from administration, once you file your paperwork, you can have the documents you need to transfer the assets within a matter of a couple of weeks, depending on how busy we are in processing those documents. So it's a very streamlined process when you go through the release from administration. Sometimes you have to convert that to a full administration because some things may come up. There may be assets discovered that you didn't know about before, and you can always do that. So there are a couple different types of releases. You have what's called a short form release, and that's it's a $20,000 limit if you have a surviving spouse who inherits everything, and a $10,000 limit when you have individuals other than a surviving spouse. And you'll see that if you have a surviving spouse, a lot of times you'll be able to file these smaller estates because there is a larger amount that the spouse can receive under the law than, say, a child. So it just depends, and again, everybody's situation is different, and if you have a spouse, a lot of times you'll be able to file these smaller estates. The big thing is that in this, the applicant has to represent that there is no creditor that is being prejudiced by the filing and that all debts have to be paid. So a big debt when someone passes away is the funeral bill. You have to file evidence that the funeral bill has been paid. There may be some other debt out there, and you just have to make that indication that debt is being paid. There may be some credit card bills or some other debt. And so you have to make sure that debt is taken care of. For this, and again, we get to, everybody thinks that the probate court is very expensive. If you can file a short form release, it's a $30 filing fee. So it is very inexpensive. The next we have is a summary release. And again, the applicant has to have paid the funeral bill in full. And we would require a copy of a receipt showing that the funeral bill's been paid. There is a limit of $5,000 or the amount of the funeral expenses that have been advanced, whichever is less. And those are for applicants who are not a surviving spouse. Now, if there is a surviving spouse, there's a limit of $40,000 plus the funeral bill not to exceed $5,000, which means if there's a surviving spouse and there's less than $45,000 in assets, you can file this type of release. Again, if it's just a child, then you can only there can only be up to $5,000. If there's more than $5,000, you can't file this type of release. So as you can see there, again, if you have a surviving spouse, you can file these smaller types of estates if you have a little bit more in assets. In this case, you do not have to make a representation that all the debts are paid, and there is no requirement that all the debts are paid, except for the funeral bill. That has to be paid. But if there's credit card debt out there, it doesn't necessarily have to be paid, especially if there's a surviving spouse, because they're entitled to that $40,000 plus the funeral bill up to $5,000. And they have a higher priority as far as payment is concerned. So that's why you don't have to necessarily pay those other debts that are there. This type of release from administration is a $60 filing fee. So again, we're looking at less than $100 in court costs, and it's a very quick process. This, you could have your paperwork back again within a matter of a couple of weeks, maybe even less, depending on how busy the court is. Then we have what's called a full release. There's a $100,000 limit on this type of estate if the surviving spouse inherits everything, a $35,000 limit if you do not have a surviving spouse and it's just one child or a couple children who inherit everything. The applicant must represent that there is no creditor that's being prejudiced and that all the debts must be paid in order to file this type of release. The filing fee for this type of release starts at $92, and it could be a little bit more depending on if there's any other types of notices or motions that need to be filed. So you're looking around $100 for this type of release. But again, if you have a surviving spouse and you have, say, $95,000 in assets that have to go through probate, then you could file this type of release. It's around $100 in court costs. And again, you're looking at a matter of a few weeks to get your paperwork back to be able to transfer the assets. So there's not a real long time frame there between the filing and the ability to transfer the assets. And that's what's nice about these types of estates, is that you can get the paperwork you need to transfer the assets very quickly. You're not going to wait a year or 2 years. It's a matter of a few weeks. And I know a lot of people, and when a loved one passes away, they might be in a situation where they need to transfer those assets quickly in order to pay bills or, just to keep going on, to provide. And so that's what's nice about these types of estates, because we can get the paperwork processed and you can get the assets transferred very quickly. This is a new type of estate. It's called a real estate only release. It just was, the statute for this type of release was just enacted in the last few years. If a decedent passes away and they owned real estate at the time of their death, and that's the only asset that needs to go through probate is just a piece of real estate, you could file this type of release. The only issue with this type of release is you do have to wait 6 months from the time of death before you can file it. But again, if it's just real estate, that's okay, because you're not talking about, having to transfer money or anything that you might need to provide for the remaining family members. So, it's a good thing. So you wait the 6 months, and then you file this type of release. You can get the paperwork back within a matter of a couple of weeks. And the filing fee for this is only $70. So again, you're looking at something that is less than $100. It's rather quick once you have the ability to file it. And a few years ago, my dad passed away, and the only thing that had to go through probate was his half interest in the home, because my mom owned the other half, but they didn't own it jointly with right of survivorship because my dad didn't listen to his son, who was a lawyer. And so he kind of blew me off a lot when we would talk about that. And so they owned it jointly, but not with right of survivorship. Had he listened to his son, then we wouldn't have even had to have done this. We could have, it wouldn't have been a problem. So we waited the 6 months from the time he passed away. We filed the paperwork for the real estate only release, and we were able to transfer his half interest to my mother within a matter of a couple of weeks from the time of filing. So it was a very quick and simple process. We just had to wait the 6-month time period. Finally, we have a full administration. That's the last type of estate administration. And that's if you have assets over $100,000 and there's a surviving spouse, or over $35,000 if there's no surviving spouse and those assets have to go through probate. In this case, the initial filing fee to open the estate is $161. This type of estate does take longer. You're supposed to, under Ohio law, you're supposed to have it all done within 6 months from the appointment of the administrator or executor. Most of the time, that's very difficult to do, so you can extend that time. A lot of times, these types of estates are open between 9 months and a year unless there are other issues. A lot of times when we have estates that are open for a few years, it's because there might be fighting amongst family members and other litigation that goes on. That's what creates the expense and the time. I mean, you could easily have an estate administration done within 9 months to a year, as long as everybody's getting along. We have a lot of cases that people don't get along, and it's 2-3 years down the road, the estate administration's still ongoing. There's multiple attorneys involved, so there's a lot of expense, and that's what drives the court costs as well, because we have a lot of motions being filed, a lot of hearings that take place. In this case, if you have an estate administration, it's a full administration, the total court costs are probably going to be around $200, so not that expensive. We have cases that have been going on for 5-6 years, and the court costs are $1,000. But that's because people are fighting and not getting along. So those are really the main types of estate administration. I don't know if anybody has any questions. I know it's a lot of information.
Before we get to questions, this is a good time to illustrate what we were talking about earlier on about putting property with rights of survivorship. So if you have a $80,000 home and you have $40,000 in the bank and you have several automobiles, the value of your estate all of a sudden is now over that $100,000 limit for going either with a release, which he was talking about, or a full administration. And in the full administration, you see all of the problems that can develop. But if you put your $80,000 house on a transfer on death, and you put your $40,000 in the bank in a survivorship account, and you have your cars transfer on death, how much property do you have in the estate?
There's zero.
Zero. So now you've avoided the entire lengthy process, and you avoided the fighting among the family members. You avoided all of that extra expense and time and lawyers' fees, etc. If you just take those extra steps. Now there is a charge when you put real estate transfer on death when you file at the probate or at the recorder's office. I think it was $28.
Well, it's probably around $40.
$40, okay. But look at what you can do when you look at the estate administration. Look what you can do without even having lawyers involved in terms of going from a full administration to a release from administration. Okay, sorry to interrupt.
Oh, no, that's okay.
I thought it would be a good time to illustrate the difference in what you can do on your own. But again, everybody's different. Everybody should talk to a lawyer about doing that. If I were a lawyer and you came in, I would take inventory of your assets, talk to you about what your interests are and what you want in life, and what you want to happen at the time of your death, and then they can give you a more appropriate advice.
Sure. Yes, sir. Okay.
There's 2 children involved. They're wrong. They don't want the court. They don't know nothing. They just say, get it over with and be done with it.
Okay.
There's no property law. There's no testing of anything. So how long will something like that take?
So the question is that we have an estate administration that's been open. There is no fighting. You have two children. Everybody gets along. They just want everything to get done. So how long should that take? Again, it depends on the assets and what type of assets you're dealing with. I know when I was in private practice, I did a lot of estate administration. And if you have just simple bank accounts and real estate and everything, it doesn't take that long. If you have investment accounts, it takes a little bit longer to get transferred. So it depends. Now, in a case like that, if you just have some real estate, some simple accounts, you should be able to get that done, I would definitely within a year, probably faster. You know, I would say maybe 6 months to 9 months at the most. But again, it just depends, because you may also have some debts out there that need to be taken care of. There's no debts, everybody gets along. And I would say you could probably get it done 6 months, but it just depends.
I should tell you that Chris, he's the chief magistrate, and he handles estate administration. And after every estate closes, I send out a survey. And most of the surveys come back, everybody's satisfied, this, that, the other thing. But the ones who are complaining about the length of the estate, okay, how long it took to close the estate. And every time I get one of those surveys, I give it to Chris. And I have Chris investigate, why did this estate take so long? I got a complaint that the estate took so long. And almost every time it comes back what, Chris?
Usually it comes back that the lawyer took a little extra time. Because they're busy, or they have other cases going on. So sometimes that's why it takes a little bit longer. There's no lawyer involved. Well, then I guess it's up to the children, because I'm going to assume one of them is the administrator or executor of the estate. Oh, you are? Okay.
All right, well.
Now you're really putting me on the spot here. Right. So
that's a goal of ours at the probate court. When I took office back in 2015, we met with the magistrates, and the idea was, the biggest complaint was the length of the administration of the estate. And I emphasized with the magistrates, and they've been very good on this subject, when we get the documents in, they are reviewed quickly. And when they send me recommendations on what we should do with respect to this particular motion or this particular order, et cetera, I try to get it back to them within 24 hours. So we make a strong effort to get it done. So if you are having an issue, or someone does have an issue, contact us. We'll look into it. We'll get it done.
Right. I can tell you this: if you open a full administration and you file the paperwork, and all the paperwork is in order, everything's in order, then a full administration, it comes to me, and we will have the fiduciary in a week of filing. Sometimes, depending on how busy we are, if somebody's on vacation or whatever, it might take a little bit more than a week, but I would say, at least 95% of the time, it's less than a week. So we've really streamlined the process at the probate court, and I'm pretty proud that we get things in and out very quickly. Other counties are not as quick, I can tell you that. So again, I don't know if you're having any issues. You've got everything in. I don't know where things stand, so. Okay. Okay. Oh, okay. So okay. Yeah, so you had an issue with the way things were the name that they were held in, so you had to add AKAs. Yeah, sometimes that happens where people will own multiple pieces of real estate, and they'll own it. The name will be slightly different on each piece of real estate, so you have to make sure that the paperwork has all of those names on it. or else you go over to the recorder's office and sorry, we can't transfer this piece of property because this isn't the name that it's held in. These are all little things. I tell people all the time that probate is very detail oriented, and you have to make sure that all the I's are dotted and the T's are crossed on that. So yeah, if you've discovered that situation and you've got that filed, then they called you and you corrected it? Okay. Well then, I mean, that paperwork's being processed. If it hasn't been processed already, I'm sure it'll probably be processed in the next week. I mean, now with that being said, one of our clerks is on vacation. So I don't want to make a promise. That's really what slows us down, is if we have, somebody out, because then the rest of us have to kind of pick that up, and we're spread a little bit thinner for a few days or maybe a week. But when we have everybody there and we're operating at full strength, it's a pretty streamlined process. Just not this week. Yes, ma'am.
If there's no surviving spouse, you only have adult children, and you do have the transfer on death as far as your real estate and everything else goes, your property, cars, whatever. Okay. And what I want to know is, if you do have some debt, is that executive responsible to pay the debt?
Okay, so the question was, if you set up everything and all of the assets go non-probate, meaning you have transfer on death, designations on everything, beneficiary designations, you do not have to open a probate estate to transfer all those assets, but there's debt. What happens to that debt? So in Ohio, the creditors can only file claims against probate assets. So,
That's if it goes in probate, that's how they get that, to get paid.
yeah, yes. I can't give you any legal advice as to how to set up your estate plan, but I can tell you that in Ohio, creditors can only file claims against probate assets. I had a question back here. Yes, sir. The executor?
Executive. As far as being competent enough as far as to handle the whole thing. Is anyone to assist as far as, like, if you designated the position and you don't know all the ins and outs?
Okay. So the question is, if you designate an executor, can they have someone assist them if they don't know everything as far as estate administration is concerned? And my suggestion would be that that person should go see a lawyer to assist them. Yeah, that's very normal. I mean, in Ohio, you do not have to hire a lawyer to help you administer an estate, but it's always a good suggestion to do. Just because, again, probate is a very specific area of the law, and it's always good to hire an attorney who does a lot of work in probate court and has a lot of knowledge when it comes to probate. And it's always a good idea to hire somebody who has that knowledge and can assist you in going through an estate administration. Now, you don't have to. There's a lot of information out there, and even on our website, we have a lot of information, and we have all the forms that get filed is on our website, so that's a good source of information for you. But I would suggest if you don't feel comfortable or confident that you can handle it on your own, go see a lawyer who does a lot of probate work. They would be able to help you. Yes, ma'am.
Does that include, if you're in the nursing home, if you're not, I'm just asking, if you're not in probate, it doesn't go to probate, but the person is in the nursing home, and whatever occurs as far as the death goes,
Okay.
can the nursing home take from the estate?
Okay, so the question was, going back to the debt, if a person's in a nursing home and there's debt that's owed to the nursing home, can they take it from the estate? And if there are probate assets, the nursing home can file a claim against those assets.
And if there's not, if it doesn't go into probate, then they cannot.
Only probate assets. We have to be careful because I'm not allowed to give legal advice. There is, and the judge, we've talked about estate planning, but there is Medicaid planning, which is a little different. And again, you would maybe want to see an attorney about that who handles and has a lot of knowledge in both estate planning and Medicaid planning. I did a lot of that when I was in private practice, and sometimes there's a little difference between the two. So, any other questions? No? Okay. Well, I, again, thank everyone for inviting us to come out and talk to you for a little bit, and hopefully we can do this again and give you a little bit more information. Thank you.
Thank you so much, Judge Frederica and Magistrate Chivone. I put that link up online to those who are watching at trumbullprobate.org if you want more information or need to download. And I want to make mention, and I know you want to say something. I want to make mention that our own attorney, Stanley Elkins, Second Baptist own, he does do living wills, probate, and power of attorneys. I know that, I believe, do you do some of this, Mr. Caldwell? You don't do that? He's a notary. Okay, I want to make sure I know what you do. He's a notary. So we do have some individuals within our community who are working in that field and can help some of our families out. Judge?
We have extra
pamphlets.
pamphlets for those online, and we'll leave them with you so they can get them here. If you run out of them, we can get you more.
Okay.
Or they can come to the probate court and get them there.
Thank you. Thank you. Let's give them another hand for being with us. We're going to move quickly. We're going to move quickly and have Mr. Caldwell come and speak to us about life insurance products, the need for it, the different ways in which it can be used. We have Ms. Karen here as well. I don't know if there's any other agents. I don't want to disrespect anyone. Any other licensed agents? Not backyard agents, licensed agents. Okay, all right. I know Miss Erica. Yes, Erica Royster, licensed agent. And so, Mr. Caldwell, let's give him a great big hand. He's one of our own, nearly 50 years experience, I'm telling on you now, in life insurance, and he's going to share with us the need and the products that are available.
Thank you. I want to thank everybody for allowing me to come and speak. My primary thing is that I want to speak to us in honor of Black History Month. I want to say, and I'm going to choose my words, I promised my sister I would. But there is a misconception in our community about life insurance. You see, years ago, approximately up until 1967, Black people were not allowed to have the same insurance rates as their white counterparts. Over the years, things have evolved to the point where we can do that. We have have certain rights that we did not have then. My primary, how should I say it? I want to say that we need more agents in the community that are willing to sit down with our people and do it from a consulting point of view. We have people that come into our community that will tell us what give us advice on what we should do, without taking into consideration our situations. Each individual in here has a different situation. And I have to say that we have been taken advantage of to an extent. What I'd like to see, and I'm getting away from my little notes here, because it is in honor of Black History Month. First let me tell you a little bit about myself. That's what I should have did in the first place. I've been licensed with life insurance since 1972. Every year, 2 years, I go back and I get my recertification with it. I have a real estate license. I was licensed since 1978. I kept that up. At the age of 54 years old, I went back to Youngstown State University and became a certified paralegal. I'm also a notary public and a notary signing agent. Those things tie in together with what Judge Frederica was talking about. We need, and I would like to invite, I see Charlene, I see Erica, and the other insurance agent. My whole thing is to say that we need to look at things from a consultation advantage. If I walked into the doctor's office and he told me, okay, take these pills and go home, I'd say, Doc, I haven't told you what my needs are, what the problem is. That's all right, I'm the expert here. Just go home and take these pills. When I first said that I was going to do this, to talk about life insurance was not especially for the dead. There is a living benefits in life insurance. There's been an uptick in deaths of our young people, untimely deaths mostly. They come to their churches and they expect the church to do what they can to help them. I attribute that to not understanding how easily it is possible to obtain life insurance. I want the agents that are here, along with me, we make a commitment as we are here, not to work against each other, but to go out into our community and pass the word and let us know what is available to us. For some of us who may have had a problem with drugs, some of us may have had a problem with other things, there are insurance programs that you can get. They're called guaranteed issues. They're called simplified issues. We are not uninsurable as we would have been back in the day. Our children, it's been expanded to the point where grandparents can actually insure their grandchildren. For some children, age 0 up to age 18, some of the premiums are no more than $4 a month. That's less than what some of us would pay to do some of the other things we like to do. Yeah. But my point is, there's a gap. It says here, why is there a gap between coverage between black and white Americans? It's because we weren't allowed to do some of the things. I'm not going to go into detail about each policy or the intricacies of it. But my whole thing for being here, and I asked Judge Frederica to come to about the other things that tie into life insurance. I want us all to make a commitment here on Black History Month that we're going to go out and we're going to consult with our people. It's so important. I would also like to mention that as far as notaries go, if anybody that you know wants to become a notary or find out what the intricacies of that is, you can contact me for that. If anybody wants to know how to become a real estate agent, contact me. I'm glad to give you the information on that. If anybody wants to become a notary signing agent, which is another element to the notary profession, I have to keep repeating over and over again, and I don't want to be redundant, is that what has happened to us as a people is that we have not sat down and talked to each other. We have not sat down and explained to each other what we have, what is available to us. I can tell you about every policy, type of insurance policy here with no problem. But it wouldn't mean a thing to you unless I sat down with you and found out what your specific need is. I have these notes, but they won't make a difference after what the judge said. I get a little upset or a little emotional about this because I have paid death claims over the 50 years that I've been in business. I've watched our people suffer because they couldn't pass down wealth. You understand that the reason we ride through our neighborhoods and we see it in the condition that it's in is because we have not purchased the life insurance. We've not done our part so that we can pass down the wealth and keep our property and whatnot. That's why I'm saying to you and everyone else, if you know any young people or older people, doesn't matter, who wants to get into the profession and learn from the standpoint of a consultation. We are sick and tired of people coming into our community and telling us what we need. We know what we need. We live it every day. Our situation is indifferent. It's very different from the general population. And I know that Pastor Todd, maybe he's the preacher, but I'm starting to get worked up here because it's something that's dear to my heart. So when you deal with people as a notary even, what I do is I go to nursing homes, I go to hospitals, I'm on call, and there are people laying in the bed, they can't move, I have to notarize their papers or be a witness. The vast majority, you find out, did not take advantage of their insurance, and they're going to lose everything. It's such a sad situation. There are children that I've seen that, as the judge said, when I work with the probate court through the veterans court that he has there, there are people that I've watched, oh boy, I'm watching my speech here, but I've watched people come into the court. Our children in the drug court, so to speak, I've watched them go out this door to treatments that they can afford, the insurance might provide, or the money that their parents left them. I've watched our kids out of the same room in orange jumpsuits going to jail. So you see how important this is for me to ask you, is there anyone in your family, anyone in your congregations that want to take advantage of some of the professionalism that I've talked about? Unless there's someone that has a question about a specific insurance, I'd be glad to answer that. However, it's very important. I thought this was even more important than going down a list of policies and you know, they have pre-need that the funeral directors would want you to have, and we have term insurance, which some of the people we have now. I get calls from people that have had term insurance that didn't know what they were doing, and when the term ran out, they were uninsurable too. So if anybody has any questions, I prefer to do it that way about any particular policy. Just yes, ma'am. The first thing is when you purchase a term, when you have been sold or you purchased a term insurance policy, one of the questions you should ask is that, is it transferable without evidence of insurability. All term policies, not all term policies, but a term policy should have the provision that you can transfer that to a permanent plan or a whole life plan. You see? And that whole life plan would last you to some go to 120 years without ever changing the premiums. Those are the questions that need to be answered. It's called without evidence of insurability. If he can't give you that, or if he can't answer that question, then you need to look further. Yes, ma'am.
I just want to ask you a question as well. I have a policy I've had over 30 years. 30, 31, 32 years ago, of course, it's a $15,000 policy. Okay. During that period of time, I've put way more than the 15,000 into the policy. It's a whole life.
Mm-hmm.
And so, as of now, I probably paid probably $16,000 or $17,000 into the policy. So, if I cash it in, the cash value, I called Metropolitan, is only like $10,000 cash value. And I don't quite understand, so, and I paid like $43 a month,
Mhm.
a little over. So, do you continue paying on that? I mean, I know life insurance.
Yes, ma'am.
I'm up in age now, so, but.
Well, there's a history to that, ma'am. Metropolitan, Prudential, and a few other of the large insurance companies were sued because if you had it over 30 years, there's a good chance that you had one of the policies that was where you were overcharged. So what I'm going to say is to you is that in every permanent plan or a whole life policy, the government has put as what's called non-forfeiture values. That means that you have paid on that policy. You can call the insurance company up and say it's paid up, okay? If you don't want to pay any more on that policy, the cash in that policy that you've paid will keep that policy in force without you paying another dime. What I'm trying to say is that a friend of mine, Sam might remember this, we went to a lady that lived in Highland Terrace, and it goes right along with what you're saying. We have policies, and we've paid for them for years. And we stopped paying on those policies for whatever reason, and we say, well, it lapsed. You throw it in the old junk drawer there. I want to tell you that it's virtually impossible to lapse an insurance policy. We went and looked at the elderly lady's policies. She had $3,000 cash in those policies. The insurance company is not obligated to tell you that. So, and this is, here again, ma'am, that's what the point that I'm saying. I get emotional about it because we've been ripped off so much. The thing is, an agent, some of the young people in this organization, can get out into the community and talk to people like that have questions like that. I can't do it all by myself. But you can call that insurance company and you tell them you want to know how many years, when you can stop paying on that policy. And you've overpaid, I think.
Yeah, I was overpaid, and I did call,
Mhm.
and they told me, and I'm wondering, about, I don't know how many years ago, not that long, in December, they'll send me a dividends check of $300. Okay, so I called them, and I said, well, something would happen to me today if I would die today. When I get to 15,000, they said, no, only 14.
Mhm.
And so what, I mean, what, okay, $15,000 policy?
Yes, ma'am.
Okay, 6,000 or more.
Yes, ma'am. You see, you had what was called a participating policy. Now, we will find out, and they said that they sent you dividends. There's no such thing as dividends in a life insurance policy. What they do is they overcharge you and they send it back to you in payments. If it were a dividend, you would have been taxed on it by the IRS, and they would have been after you for that. There again, our people perish for the lack of knowledge. What I'm trying to, if I were you, there you have two ways to do this. Each insurance company is regulated, especially in the state of Ohio, through the Department of Insurance, State of Ohio Department of Insurance. You have a right to file a complaint if Metropolitan is not living up to your standards. Do you have an agent with them now, or is he? Well, you have a right to call Metropolitan. Yes, ma'am. You can call them and make them send you a statement saying that your policy is paid up. Once it's paid up, you're not obligated to pay any more money to that. And after 30 years, I'm almost certain, I can't say with any certainty, but I'm almost certain that you shouldn't have to pay any more for the rest of your life on that. Yes, ma'am. Anyone else? Yes, sir.
So, if you have or have had term, and I signed up for term, and when I was first married, around the time I had our first child, I don't know where that paperwork is. I think one of the companies has been bought out or transferred, or someone bought the policies. Is there a way to research that and find out who owns the policy and what its status is?
Yes, there is. There's a department in the state of Ohio, operated by the Ohio Department of Insurance, that if you can find a Social Security number of the person that was on that policy, an account number that was on that policy, they have records of them. A lot of people don't realize that the policies that we sell, the paper that we give you, that's not the real policy. The real policy is on file with the state of Ohio.
You have to have the account number, though.
An account number, Social Security number, and they can trace it down.
So if I don't have the paperwork that would give that account number, I'm out of luck.
Not necessarily. They have companies now, which I've operated with, that I can get the information to you for, that will actually do the research and find that policy for you. Okay. And these are some of the secrets, yes, they are secrets, that have been kept away from us. And I'll repeat that again. If there are any people, any young people that really want to serve their community, and I kept it this way because it's Black History Month, that we should contact myself, if you will. I'll give them the guidance to get into it, and most of all, become consultants. There's just so much that we go through with our funeral directors even. There are things that need to be said about when a person passes away as far as bringing your policy to the funeral director. There's so many little things that we need to know, and I appreciate Pastor Tarter giving me the information, that allowing me the time to say these things. I'm trying not to get bitter, but it's hard. when you've been disrespected for so many years. I've been here since 1972 when I first got my license. And every 2 years I've watched this thing change and change and change, and I've watched us fall further and further behind. I've watched our communities decay. I've watched our children not being able to go to college. I've watched just a myriad of things that could be prevented had we had the knowledge. And yes, ma'am. Well, see, those are two things, and I'm in the midst of some of that with a family member. I'll go along with what the judge said there. Anytime there's a contention in a contract, it's best to get legal advice on that. I have had a real estate license. I've watched us, for instance, be redlined. I used to live at a place called 744 South Park Avenue. We used to call it the Flats. We owned our own homes, we had businesses, we had stores, we had everything. all right? We owned our real estate. In comes community development, or urban renewal, it was so called. When we looked up, we lived right next door to this church, and they were populating the Highland Terrace. You see, redlining. I've been in situations where they won't give you the same benefit as they would a white client. If I went to buy a home, they're going to charge me so much more. So I would send a white friend in, and then, then you have a lawsuit. There's so many, I understand what you're saying, Erica, and it's so many things, they all connect together. We all have to be, we need more consultants that can connect these things so that we can rebuild our community and rebuild our lives. Any other questions? I'm sorry that I did not go into detail. If anyone has any wants any detail about any specific type of insurance, I'm welcome to do that. But I thought it more important to elaborate on the condition that we find ourselves in Black History Month. Yes, ma'am. Mm-hmm. Okay, a whole life policy, let's say it combines term and the cash value element together. A term policy is only good for as long as the term. You have 1 year, 2, 5, 20. You hear on TV where they'll tell you, I can get you a $5 million policy for $100 a month. Term insurance, primarily I would say, is for young people who have a lot of obligations. You can buy a lot more insurance, and it's, should I say, less expensive at the time. Your children are grown, your expenses go down. You should be able to, you should always, I would say, mix the two. If you can have a whole life policy and a term policy according to your needs. It's hard for me to say specifically, but the differences are they're vast. But most of the time when people say if you have bought a 20-year term, which we used to sell, 20-year term, at the end of the 20 years, let's say you developed a heart condition, and the 20 years is over. At the end of that 20-year term, that policy rate's going to go up, probably to a point you may not be able to afford it. So what I say is that you have a whole life or permanent plan alongside that, a term. An older person, I sell primarily now is senior life. It's for people from 50 to 85, and with all different types of health conditions. But we need more people. And the reason I keep saying this is because it's such a need for us to have someone to come and talk to individuals like yourself about that. And yes, ma'am.
I do want to say this. There was a misconception on term insurance way back. Now today, if you got someone 50 or under, like my son passed away, he left a daughter here. He didn't leave anything for her. So what I did was I bought her a $100,000 term policy for 30 years. Okay, he didn't leave her any wealth, but that policy will, because it's a return of premium. She can take that policy in 30 years and take the lump sum money, or she can flip it over and say, I'll never pay for insurance again. You gotta know what type of term insurance you're buying. And I am here for questions, and I'm just like you.
No problem.
It's crazy about the way they do our people.
Yeah.
And it's time for us to educate our people, not just try to sell. but
Absolutely.
educate.
There's an element to that, what the young lady said. We had a concept years ago, it was called buy term and invest the difference.
You're right.
And so if you say your premium was $50 a month for a $100,000 policy, if you were to take $20 more and put it in an account with compound interest, and let's say you were 20 years old, and when you were 40, you would be in very good shape. The problem was that when we did it, we bought the term, but we didn't invest the difference. See, So again, this is what we need to do to bring ourselves up to par. You will see our community go up. You will see we'll be able to pass our assets down to our children. We'll be able to start building in the right way. But as it stands now, we have work to do, and I'm willing to help do my part to help if necessary. You-
Because people are running out there to state their velocity because they think they're saving money. But and this is what I did personally. When my nephew was here, I went to state Nebraska, I got his prices. I took that price to Sterling and asked him if he would match that price if he did. And it's funny to me that we're running to them, but how many of them are coming to our Blackburn?
I can answer that. There's a thing called, and I said this the last time we were here. I have your permission, Pastor? Yeah, you got my permission. There's a thing called post-traumatic slave disorder. We are all suffering from it. It was passed down from the time that our people were on the plantation. We don't mean to be that way, but we don't have a choice. All right? We have in our community, and I'll explain it to you. You've heard of Harriet Beecher Stowe's book called Uncle Tom's Cabin. In Uncle Tom's Cabin, there was 3 primary characters: Simon Legree, the slave master, Uncle Tom, and Sambo. Now, to make it short, Simon Legree, the slave master, told Uncle Tom, "Here's the whip. I want you to beat those slaves. They need to pick more cotton. We need to put them in line." Uncle Tom said, "No, these are my people." He handed the whip to Sambo. Sambo beat Uncle Tom to death. Now, the moral of that story is that we have Sambos running around in our community here. At the bequest of those, they would take the insurance book, they would beat you to death with that or anything else they have. The thing you need to know is how to recognize a Sambo, all right? And they're everywhere. We have them in our families. We have them as friends. But make sure you understand that our primary enemy is not white people. They are the Sambos that we allow to do things to us here. We have Sambo insurance agents. We have Sambo real estate agents. And they will beat you to death at the bequest of the person who wants to control you.
The other thing I want to say, in this day and age of technology, you can just about find anything that you want information on. There's a website, it's called Parting, PARTYING.com. And you can go in there, you can compare the prices of the different carriers.
Yes, you can. See, that's a state rules. I didn't bring that with me. I wasn't going to talk about it, but there are rules federal rules that funeral directors have to go by. There are state rules, and they are readily available. But I caution you, all those things that we're talking about really don't make a bit of difference until you have someone that has your best interests at heart, and that's not a Sambo. Weed them out, or we'll never get anywhere. They're in everything: politics, insurance, real estate, name it. Churches. I wasn't going to say that, Pastor, but thanks for the help. Yes, ma'am. Okay, that's called a guaranteed issue. And it's for some companies it's 3 years, some companies it's 2. The benefit of that is, now I tell people this too, when I would fill out an application, one of the questions is, have you ever had chest pain? All right? And some of our people, you're not a doctor, you don't know what that means, so you'll answer it. You might have ate too many of them ham hocks and beans, and you might have been gassed. So you don't, when you answer a question, you answer it to the best of your ability. The reason I said that, what you're saying is that some of our people need the 2-year buy down. That means that if a person's been in prison, if a person has had AIDS, if a person's had any debilitating diseases, they're not going to give them the same policy that you would normally get. They wait the 2 years because that is to assure, that's to help them insure themselves. But the 2 years that you have to wait, all right, means that you don't have to answer any health questions. And more importantly, you don't have to go in what's called the MIB, the Medical Information Bureau, which has a file on every one of us in here. You see, insurance is based on actuarial science, the same science that was used to land a man on the moon. We're all in this room. An insurance company can come in, they can tell us how many of us going to die to the second. But they just can't tell you which one of us. That's up to the, and it's true. Yes, ma'am.
Okay, you mentioned the MIB.
Yes, ma'am.
That's another thing we don't know. You go to the doctor, and they'll tell us, oh, you got this, and they'll write a prescription. And we take that prescription and we throw it away. We don't take it. But then when you go get insurance, that MIB is going to show that you're taking this prescription.
There you go.
And it's going to count that against you. And that's when you got to have a guaranteed policy.
Yes.
You don't want a guaranteed policy. You should be able to come in, I'll write you an insurance policy, and you are covered that day. But when you go in, like he said also, don't tell them nothing they ain't asking for. If they don't ask you that, don't give them this stuff. You know, like, oh, well, I went to so-and-so, and he did this. That ain't none of their business. Only answer what they ask you. And watch your doctors. If you don't need that, you don't put my name on that, don't write that prescription. Because it's in a database, and anytime your name go in there, they gonna know that you is free. You might, and it's nothing you even pay.
And it's,
They do that to us.
absolutely, and it affects your credit reports. I do things on credit clearing. I've done that, credit accuracy verification. I'm saying that all these things tie in, and we wonder why we find ourselves in the condition that we're in. It's because we don't have anyone to come into our community and consult with us about, it's like what the young lady said, between myself, Sam there, your young lady here, Erica, we all have run into different people in our practice. But there's so much. We need more. We need younger people. We need more people involved to get the message out. So I apologize again for not going in depth on any policies, but
Just a question or two more.
any more?
Wrap up. Mr. Amos, did you have a question?
I got much. How do we determine the premium?
Return to brief.
Return premium. Okay, you took a term life out, and you said I'm taking it for 20 years. At the end of that 20 years, you have a choice of taking every penny that you have paid into that policy back, or you can say, because at my age, over 50, we gotta pay for insurance till we 99. You're not gonna stop before then. But if you get a term and you get that return of premium, you can take that return premium on that 30 years and take that lump sum, or you can flip it and say, I'll never pay for insurance again. It's paid up, and that's what we're saying.
Yes.
It's paid up. You should not have to pay for insurance again. That policy, I would like to, it should be.
That's what I mean. And there's so many of us now, and even so, check the policies, take numbers of people that have passed, policies that you have at home. Try to find out as much information as you can about them. And we can all, I'd be willing to, and I know she would, to be able to sit down with you and go over them. Yes, ma'am.
What does it cost per thousand?
Okay, sir, that goes into, I need your age, how long you want it, it starts at 10, 15 years, you go up to 30, and your profit, are you over 50?
I'm just asking for information.
Okay, so you're under 50,
Hold on. I'm a five-term investor too.
okay.
So the understanding I've had, years ago, I took out a 20-year level, and they had guaranteed insurance.
That's what I was speaking to.
One factor you put on there was people very for lack of knowledge.
Yeah. Okay. I want to thank everybody for listening to me and having me here. Thank Pastor Todd for putting this on. And hopefully some of the agents here in the audience, we'll all get together. Maybe we can form a little consortium where we can get out there, help recruit people, and even put some more information out into the community. That's what the most important thing is to me. I thank you.
Give a great big hand for Mr. Caldwell. We're so grateful. I wanted to get you guys out in under 2 hours, and we are right there. So thank you so much for coming, and I'm thanking you in advance for sharing this information with others. This is so vital to us for putting to practice what we all want, and that is to secure and pass down wealth, property, assets, and resources to our community. I want to make a commitment right now, since it was mentioned by so many. I want to dedicate at least one day, whether it's either here at the church or the Focus building where we have offices, that those individuals who are mentioned and other recommended individuals can consult with individuals by appointment, and we set a community insurance and living will and probate day or whatever, or notary, even our notaries, we have notaries, that they can set some appointments and know that once a month they can come down to the Focus building or to the church, and they can get their questions answered. I just scratched myself. They can get their questions answered and maybe get signed up and do actual appointments. And we'll use our social media, we'll use our page to get the word out. And I'd like everyone to, if you don't have all the information you think you need, to set an appointment and do that and bring one person, especially a younger person. Because right now there's a funeral going on for a 43-year-old young lady in my own generation right now. So life, is not guaranteed to any of us. We preach it, we teach it, we talk it, but it doesn't matter if you're old or young, we all have to come by this way, all right? So I want to make that commitment. We can start next month. You let me know, and we can have that done. To Erica, Miss Charlene, Miss Karen, and Karen is our resident life insurance. I'm just going to designate her our resident Second Baptist life insurance. There's a pew waiting on you. I'm going to say it out loud. I'm joking. And we need more. And so let's do that and make a commitment, because all of us represent families and friends and coworkers and neighbors that we can get the word out to, because we would hate to be beside that family member, that friend, that coworker, that neighbor in a time of need, and they could have had in place, and they don't. So let's make a commitment to doing that, all right? Thank you so much for joining, for tuning in. Please let somebody know that there is good information. Ms. Rucker, thank you for posting. And that when I saw your post, I was scanning Facebook. You said bring it back next year. I said, no, we're bringing this back next month. And so I want to set a block where you can set appointments. We can set aside 2 or 3 offices, and we can get our people not just educated, but now signed up and consulted with, so that we have what they need. All right? We started with prayer. We're going to end with prayer. Pray that your rest of your weekend is a wonderful time. Service starts at 10 a.m. in the morning, Sunday school at 9 a.m. If you don't have a church home, you know where to be, all right? You know how to find us, apparently. So if you don't have a church home, you're more than welcome to stop by. Let's pray. Father, we thank you, we bless you, we honor you for this opportunity to do more than just worship and sing and preach and pray, but to educate and empower and inform our community. We know that you desire that we be knowledgeable, that we have wisdom and discernment, and you have declared that we should leave a legacy, a heritage to our children and our children's children. Lord, we pray that you help us in our community to be motivated and invigorated to do the things, to follow through, to gain the knowledge, and to stay committed and disciplined to building the wealth, the stability, the financial future that we need for ourselves and our families. We thank you for the judge, the magistrate, Mr. Caldwell, for being with us. We pray that you bless every person here and all that they do, and give them peace in their journey ahead. In Jesus' name I pray, amen and amen. I love you all. Take care. See you soon.